Mediating Legal Malpractice Claims. Good afternoon. My name is Neil Burns, and I've been asked to talk about mediating legal malpractice claims and what that means and do we do it. Well, a mediation means that both sides feel they have sufficient information to try to come to the middle, and they hire a mediator, a lawyer, who's experienced in that area of law, and he or she tries to get folks to come to the middle. You ask for $1 million, they offer zero. Somewhere there's a middle. That doesn't mean it's the middle of those two numbers. Of course not. So, but before you mediate, you need to have a strong case. You need to be in a strong position. You need to know what the other side knows. You need to have either all the information that they have or enough information to feel like you can go forward with a trial, because you can't go in there and say, well, we would get a doctor to write a report that would say he's permanently disabled, but we didn't want to spend the money for that. Then the mediator says, well, is he permanently disabled? I don't know. He says he walks with a limp and it'll be permanent, but the mediator's not a doctor. And the other side's certainly going to say, well, we don't know. It's not permanent. So you need your information. And also the attorneys for the defendants come in these cases and they say a lot of things. Some of them aren't true. But if you've done discovery, you can say, well, that's not true because of this and that. Or that's contested because he says this and she says that. And we all know what that's going to mean. So when you get to a mediation, you need to be in a strong position. You really need to know your case. Sometimes you know a little bit more than they think you know. Sometimes they know something, and that's not helpful if you didn't know it. What does mediation mean? You go to a mediator, you present your mediation brief, your story of the case with case citations and medical records or documents and things of that nature, and you show the mediator that you're ready to go forward, you're ready for trial. Or the other side presents their side. And then sometimes there's some discussion about where we can at least agree on or agree what we don't agree. And then in a mediation process, they put you in two different rooms. In Zoom, they put you in two different Zoom rooms. And the mediator bounces back and forth. Your room with your client and the room with the defense attorneys and the defense, the insurance companies. And the mediator tells you where your weaknesses are and tells them where their weaknesses are. And it goes back and forth. And the process works, they tell you 90% of the time, and they're probably right. Sometimes a good mediation won't result in a settlement, but will result in moving towards a settlement, in which case the next day, the next month, just before trial, you can settle. We had one case that was ready to go to trial the next week. We were in a mediation on another case, and the mediator called and said, the other side wants to talk. So we were in a mediation on one case and a mediation on another case and resolved both of them. But you need to be in a strong position, and you need to know when to stop and know when to move on. Either stop the mediation and it's not working, or stop because it's good enough and you can settle the case at that amount. If you think your case should go to mediation, if you want to talk to attorneys who have a lot of experience with mediation, I've been in this building at 6 Beacon Street since 1987, a lot of experience, I've done a lot of mediations all over the Commonwealth. Give us a call, 617-227-7423. Thank you.